Hello everybody. My name is Shaskya Villarruel, and today I'll be interviewing Professor Lisa Bernstein, Wilson-Dickinson Professor of Law at the University of Chicago. After obtaining a BA in Economics from the University of Chicago in 1986 and a JD from Harvard Law School in 1990, Ms. Bernstein served as a clerk for the USA District Court of the District of Massachusetts and was a visiting research fellow in law and economics at Harvard Law School. Also, Ms. Bernstein has been a visiting professor at the Hebrew University, Tel Aviv University, and in the College of Law and Business in Ramat Gan. Also, Ms. Bernstein has wrote a book titled Customary Law and Economic with Francesco Parisi. This book is divided into 3 sections. The first section, it's about history of customary law. The second section, it's about commercial customary law. And the final part treats about the role and limits of customary system in a variety of commercial settings. So, Ms. Bernstein.
Thank you very much. It's a pleasure to be here.
It's a pleasure for me interviewing you. All right, so we can start with the questions. The first question is, please, can you tell us more about your academic background? How did you become a professor at the Chicago University?
Well, I think the most important thing in my academic background is actually not academic at all. And that is that I'm the daughter of a contracts lawyer. And my father liked to always say that he raised his kids according to the common law of contract. So I kind of grew up living in the world of the common law. And then when I got to law school, fate had it that I was called on the very first day of contract class for the very first case. I stated the case, and at that moment I knew that teaching contract is what I wanted to do for the rest of my life. And strange as it sounds, I never once looked back or wavered from that. But I would say my real big break came when I was taking a law and economics class from Stephen Chevelle at Harvard, who turned out to be one of my truly great mentors. And Steve had given us about 700 pages of reading for one night. And I thought this was a little excessive, but I did it because I'm a nerd. Turned out, of course, he was just giving us these materials for reference, but I took them pretty seriously and went into his office and I said, Steve, if this Bob Ellickson fellow at Yale can become world famous for writing about whales and cattle, why can't I become famous writing about diamonds? And Steve, in his very Steve-like way, said, well, Lisa, can you tell me what's similar about diamonds? I did. And he immediately said to me, well, why don't I give you a law and economics fellowship at Harvard so you can write your paper about diamonds and become as famous as Ellickson? And it was that paper, which was picked up in the Journal of Legal Studies, that was sort of instrumental in making my dream of becoming an academic come true.
That's awesome. That's impressive. Moving into the next question is, we wanted to know more about your experience as a top academic and researcher in the context where main researcher seems to be majority.
Well, I think my experience might not be typical of everyone's experience, but I'm willing to share it with you. So like I said, Steve Chevelle, joined by Louis Kaplow and David Charney, were my 3 male mentors in law school as far as law and economics was concerned. And so while I was in law school, I never really thought about the question of, are there women in law and economics? Because they treated me just like they treated everybody else. I think I first really saw and noticed the lack of women when I went to my first law and economics conference. And I noticed that it was the only venue I'd ever been in my entire life where there was a line snaking out of the men's room and the women's room had 3 people standing inside of it. It sort of hit me, this is very strange. I then forgot about the whole issue again until the following year's conference, when I snuck out of the after dinner speech to listen to the Knicks-Bulls game on a transistor radio. So this already tells you I'm pretty old here. But in any event, I was standing in my suit, and this is, for reasons that will become clear, the last time I ever wore a business suit. listening to the ball game through a microphone. And all the men who came out to use the bathroom thought I was the bathroom attendant and started to give me tips for monitoring the bathroom. They would hand me their dirty towels and a dollar bill. So right there, I decided, there's something going on here. But in my judgment, it was best not to react. So I just accepted the money. And when the dinner broke up, I went to the hotel bar with some of the guys and used the money to buy them a round of drinks. So for me, I've mostly navigated this with sort of humor and trying to march ahead no matter what. But I think it's also in some sense fair to say that the older generation of mentors, the ones who mentored my generation, were unusually open for legal academics to opening the door to women. And I've never felt, from them at least, any sort of discrimination, any kind of exclusion. In fact, when I look at legal academia as a whole, I would say that law and economics is a little bit of a bubble where gender matters far less than it does in other areas of law.
All right. Third question. What do you consider to be the relationship between social structures and economic development?
Well, I would consider that particular connection really fundamental. In fact, as I've begun to study and write about social network analysis over the past couple of years, I've come to really believe that there's no way to understand how contracts, institutions, and government regulatory policies are going to affect behavior in the everyday world unless you pay attention to the underlying social structure. And as I sort of go back over my own work, I realize that some of the importance that I attached to social and ethnic homogeneity and to various types of formal institutions might have been a little bit overstated. So in recent years, I've been going back over my old studies and really trying to highlight the role that social and institutional structures played in supporting trade in the contexts I wrote about.
All right. Where are current contractual regulations and commercial law hitting?
Well, that's a tough question. I can give you sort of a pre-COVID answer. I haven't really had the opportunity to fully think through how COVID will affect things. But I'd say I see them heading in a more privatized direction, in the sense that litigation just doesn't work or really add value. The prospect of litigation doesn't really add value to the vast majority of contracts that people enter into. So I really think that as time goes on, we're going to see more trade association run private legal systems, more exchange platforms that provide dispute resolution services to their members, and things like that. I think that businesses have pretty much realized that suing one another in court, going through one another's financial records with a fine-tooth comb and wild goose chases, waiting 5 years for judgment, 3 more years for an appeal, and then who knows how long to get paid, just isn't really the way to go. So when I talk to practicing lawyers and talk to people about real-world situations, what I try to do is to help them construct contract governance structures that are actually going to make these relationships work on an everyday level, rather than encouraging them to sort of edit their liability provision by moving a comma or word their indemnities a little bit broader. I'm trying to sort of move people both in the real world and in my contracts class towards thinking about this as a managerial problem that really requires you to draw from what we know from business management and integrate it into contract management.
All right. In regulatory terms, in your opinion, what are the most notable changes in the field of motor supply chains relationships, social network analysis, and the intersection of the strategy and relational contracting?
That's a tough question, because I think the answer is the real change is people increasingly recognizing that all of these aspects of a transaction or a transactional setting have to be considered together. And so I think that the real change is the bringing together of these different disciplines and applying them to the question of how do we really think about managing contract relationships to ensure that parties get what they want, and that at the same time that we do it in a way that's going to further and support innovation rather than squash the innovative tendencies of both parties. So I think now we have this sort of dual challenge, because as I say to my students in most of my courses, look, today if you're in a procurement contracting relationship, and you enter into an agreement, you're really contracting for two things. You're contracting for the thing you need today, and you're really contracting or hoping to contract in the future for the thing you need in the future, even though you don't know what it is and your supplier doesn't know what it is. You want to choose contracting partners and create structures so that your suppliers are going to be able to innovate for you in the future, and you won't have to bear all those switching costs that go along with choosing a new partner, understanding their operation, learning to speak their language, coming to trust one another, and to forge the interpersonal relationships among employees that really play the key role in cementing the agreement, more than sort of anything written by legal counsel.
Yes, ma'am. So our last question is, for an emergency and a transitioning economy like the Ecuadorian, what will be your general recommendation regarding the design of new commercial cards?
I think that the key thing, and something that really is not done enough in the United States, is to think about the creation of specialized commercial courts staffed by judges who really understand the economics of business, and to adopt very clear contracting rules rather than vague standards based on customs or usages or what's reasonable. And then to have the judges write detailed opinions where they explain their reasons, and have those opinions really available to people in the business community. So that if I'm trying to decide whether to deal with you, I can see from the files of the court online how you've behaved in your prior business relationships. Are you someone who runs to court when the slightest little thing goes wrong? Are you someone who tries to work it out but wound up in court because you were dealing with someone unreasonable? These are really important things for people to know when they choose their contracting partners. So I think that in any developing legal system context, those are going to be the building blocks for really supporting commerce. In addition, I think that there's another thing that needs to be done if you really want to support business courts that has nothing to do with the court system itself. And that is to encourage the formation of business associations where business people come together either for, purposes of discussing best practices, or even just for the purposes of playing chess for a weekend or going surfing. It really doesn't matter what they're doing there, so long as they have an opportunity to gossip. Because if transactors know that other important people are going to hear about their wrongdoing, they're much less likely to engage in that wrongdoing. So I think that at the same time as you build up the legal infrastructure of trade, it's equally important, sort of going back to your previous question, to take steps that simultaneously strengthen the social basis of trade.
All right, so thank you so much. This was the interview with Professor Lisa Bernstein. For me, it was an honor. Thank you so much for giving us your time. Thank you to my college, to my teacher, and I really appreciate it.
Well, it was fun for me too, anytime. Thank you so much.